Professor and fellow classmates. From the readings this week, I learned a lot of laws which have been put in place throughout the years to help children and people whose first language is not English. I also learned a lot about the names and how children who did not speak English used to be recognized in our school system. In chapter 1, I learned that many years ago they were first trying to figure out how to specify English children who did not speak English as their first language or at all, and they have been called English language learners, English learners, and they have also been called limited English proficient. But eventually they came around to another term, which was emergent bilinguals, and more people agreed that that was a better term because calling the children emergent bilinguals was a name that did not focus on their limitations, which means that their family and community's language practices were seen as an educational resource and not a hindrance. Instead of assigning blame to parents and community for language practices that may not include English, the school can begin to see the parents and community as the experts in the student language and cultural practices, which pretty much are the basis of all learning. So something that could be and was honestly used to be seen as a negative and a hindrance was turned into something that was a positive and could impact their students learning for the better. In chapter 2, I learned that between 1995 and 2005, so 10 years, the enrollment of emergent bilinguals in public schools nationwide grew by 56%, whereas the entire student population grew by only 2.6%. Emergent bilinguals in the United States are speakers of many different languages, although Spanish remains by far the language spoken by the highest number of them. I just found that as like an interesting fact from chapter 2, and they said that estimates of the percentage of emergent bilingual students who speak Spanish at home range from 70 to 76%. That was a bigger number than I expected, and it was really interesting to find that out. And in one of the readings about the Florida consent laws, which have been put in place throughout the years, I saw that in 1990, in August 1990, the judge of a judge of the United States District Court, Southern District of Florida, signed a consent decree giving the court the power to enforce an agreement between the Florida State Board of Education and a coalition of 8 groups represented by My Cultural Education, Training, and Advocacy Incorporated, which shortened is META, and Florida Legal Services attorneys regarding the identification and provision of services to students whose native language is other than English. So this law made it safer for children who did not just speak English or did not primarily speak English, and there have been a lot of laws made recently, but I believe that there is still more work to be done to ensure that all students, no matter their background, their race, their culture, their language, get the same successful education.